Hello, students. Good morning. Chapter 3, Medical, Legal, and Ethical Issues. In this chapter, we're going to address a whole bunch of stuff that you folks are going to be in the thick of with medical type of situations that you're going to have to deal with that you're not familiar with, or it's going to be completely strange, or something that's out of the blue that comes up that you haven't seen before. And legal ramifications, how the legal system applies to emergency medical services, and then, of course, finally, the ethical issues. So as an introduction, a basic principle of emergency care is to do no further harm. That's the EMT creed. So you need to remember that. And that's also one of those test questions as well that you're going to see popping up, here and there is do no further harm. Really important aspect of, emergency medical care for the entire time that you stay in EMS is do no further harm. As the scope and nature of the emergency medical care becomes more complex, which they do, litigation involving participants in EMS system will likely increase. So the attorneys out there that you see advertised quite often, they do get EMS cases, and you may be called in to do a deposition or even be subpoenaed to attend a courtroom session for something to do with civil liability. Hopefully not a criminal proceeding, but at least, civil liability. Providing competent emergency care that conforms to the EMT standard or the scope of practice is the key to success in protecting yourself. It will help you to avoid both civil and criminal actions. So really important. Again, competent emergency medical care that conforms with your scope of practice. Okay, absolutely. Okay, consent. Let's talk about consent. And you need to understand consent because there's different types of consent and you will be tested upon this. A person needs to give permission. Consent for you to treat, consent for you to transport. You've got to get this consent. If the patient is conscious and rational and capable of making an informed decision, they have the legal right to refuse care. They can say, "Don't touch me." They have that right. A patient may consent to some aspects of care and then deny for consent for other types of care. They have the right to do that too, as long as that they are capable of making those decisions. All right, so to provide consent, an individual must have decision-making capacity. They need to be awake, alert, oriented, person, place, time, and event, and being able to make the decisions. The patient can understand the information provided. Okay, so you need to provide them with the information that they need to know to make a decision. The patient can make an informed choice regarding the medical care. Once you've explained everything that you believe is going on with them and that you want to provide care, you want to provide transport, they provide consent to it, then that's fine. The patient has that autonomy to make decisions about their health. Remember this. This is a test question. I just saw it the other day. It's called patient autonomy. So don't miss that one. The patient acknowledges that they want you to provide care or transport. Okay. Express consent may be verbal or nonverbal. Okay. Express consent. They tell you, yes, I want you to treat me. Yes, I want to take you to the hospital. That's expressed. Or nonverbal, they shake their head. They're too sick to really respond, but they acknowledge what you're asking. To be valid, the consent that the patient provides must be informed. You need to let them know, which means that you explain the nature of the treatment that's being offered along with the potential risk, benefits, and alternatives to treatment, as well as potential consequences of the refusing the treatment. It's always advisable to document the consent in your patient care report. You're going to hear later about us talking about PCRs. That's what that means, patient care reports. So you need to advise and you need to document and you need to have signatures from people that are not within your organization but outside the organization that this consent was obtained or refused. So, implied consent. Just what we said, just the word says it, implied. It applies to patients who are unconscious or otherwise incapable of making a rational, informed decision about care and they're unable to give consent. The law assumes that they would consent to care and to transport to a medical facility if they were able to do so. Now, about implied consent, it should never be used, okay, unless there is a threat to life or limb. Implied consent only applies when a serious medical condition exists and should never be used unless it is life or limb. The principle of implied consent is known as the emergency doctrine. The principle of implied consent is known as the emergency doctrine. Remember that, write it down, you'll see it on a test. Okay, so in most instances, a surrogate decision maker may provide consent when the patient does not have the decision-making capacity. So try to get consent from an available relative before treating based on implied consent. So get the support of the team. Involuntary consent, exactly what it says. It's involuntary. This applies to patients who are mentally ill, developmentally delayed, are in a behavioral or psychological crisis. Obtain consent from someone who is legally responsible, such as a guardian or a conservator. It is not always possible to obtain such a consent. Many states have protective custody statutes that allow these individuals to be taken under law enforcement authority to a medical facility. You need to know the provisions in the state or in the area that you work in and involve online medical direction in the process. Call your medical director, call for law enforcement, get some help. Don't try to tackle this on your own because ultimately, remember the EMT creed, do no harm. So get a hold of somebody and know what state you're working in as far as what the laws of incapacitation is concerned and your role in how you can treat the patients without their consent. Okay, so minors and consent, a little bit different. The parent or legal guardian gives consent. In every state, when a parent cannot be reached to provide consent, healthcare professionals are allowed to give emergency care to a child. So in your primary assessment, if you deem that this is an emergency, you're allowed to treat the patient and transport the patient until the parents can be gathered to give consent. Usually that will happen at the hospital. Now, one of the unique things about a lot of places that this happens is at school or in some kind of special field trip event with another organization or another caregiver that has the authority of the parents. They have the documents. If you have children, you know that you have to sign permission, and you're also signing documentation that in the event of emergency, that they can give consent for that kind of treatment. Now, in some states, a minor can give consent. This is what we call the emancipated minor. It's an individual under the legal age who has legally considered an adult. Most of these cases are cases for teenage pregnancy. They have the right to make decisions about their care because ultimately they're a parent at this point. They're carrying their unborn child, and what decisions that they make for their health care also affects their child. Many states do consider minors to be emancipated if they are married or if they are members of the armed services, or if they're parents that are living away from home and no longer are relying on parents to support. So this is the teenager that doesn't live at home, lives somewhere else, and has to self-sustain themselves. Also, like we mentioned before, don't forget about the teachers. Teachers and school officials can act in place of parents and provide consent for treatment of injuries that occur at, say, in a school or a camp setting. So go find, a teacher that, can give that consent, and then they'll gather the paperwork that's necessary if you have time to collect it on the way to the hospital. Depending on the state, there may be other exceptions for certain types of treatment. Your EMS agency's treatment guidelines should accurately reflect the laws of your state or your jurisdiction. And don't forget, medical control. Contact medical control if you're having issues with this. You need to get permission and make sure that we're doing the right thing in accordance to the law. Forcible restraints. Okay, so sometimes we have to restrain patients for their own good, whether it's a mental health crisis or whether it's a mental health issue. There's multiple different reasons. Sometimes, with a combative patient, they're angry, those kind of things. These forcible restraints really fall into the category for patients who are in need of medical treatment and transport, but are combative and present a significant physical risk of danger to themselves, to others, to rescuers, so on and so forth, to their community. Forcible restraint is legally permissible. You start off with a lesser amount of restraint and to work your way up. So you need to consult medical control for authorization and then use law enforcement on scene, help them out, to get things done because ultimately it's for the good of the patient. And if we always fall back on do no harm, that's the most important aspect of this. Again, you should be knowledgeable about your local laws. Restraints are a big deal. Restraints without legal authority exposes you to potential civil and criminal penalties, so know what that is. Your service that you'll end up working for should and would, have clearly defined protocols for these situations involving restraints. Once applied, don't remove the restraints en route unless they pose a risk to the patient's health. Again, that do no harm issue. Consider calling for ALS backup because as a paramedic, I can provide sedation. I can give a variety of medications that will make the patient calm, all the way up to the point to completely what we call snowing them out with a drug so that they're not combative at all. They actually are now totally distracted with this particular medication. It's a wonderful drug. We have multiple ones. So if you're in that situation, you're not an ALS, call for ALS backup. We can help out. All right, right to refuse treatment. Adults who are conscious, alert, and appear to have decision-making capability. Otherwise, they're awake and alert and oriented. Okay, person, place, time, and event. Remember, that's a part of your assessment. That's the beginning of the assessment. You create that report. Hi, my name is EMT Jeff. I'm here to help you. What is your name? Where are you at right now? Is it daytime or is it nighttime? Tell me what happened. Why are we here? How come you called 911? What's your emergency? You just established a rapport with this person. If you can, you'll reach out and touch them. So you're, gathering that contact, that first contact when you're talking to them. But you introduce yourself. You got their name. You got that they knew where they were at. You knew that they knew it was daytime or nighttime. And then finally they explained the situation. So person, place, time, and event. It's A&O times 4. Rock on, man, you got it. So at this point in time, they are capacity. They have the right to refuse treatment, even if the result is death or serious injury. As long as they have that capacity, they can withdraw consent. If they do consent at any point in time, they can withdraw from treatment at any time, even if it results in death and serious injury again. Calls involving refusal of treatment, they really are significantly difficult. They pose a huge risk for litigation in EMS, and you need to be cautious as you proceed. So be familiar with whatever your local policies are regarding refusal of care, and know that online medical control is your friend. You can always call out and say, hey, I need help. I have a refusal patient, but I know they're going to bleed to death if I leave them. What can I do? Somebody's going to help you. They're not going to leave you just say, well, just forget about it. Not a good plan for any EMS agency. They're going to send you some help to help you make that decision. All right, so patient's caregiver. Yeah, their decision to accept or refuse treatment should be based on information that you provide. You do your assessment of what might be right and wrong. You give a description of the treatment that you believe is necessary to that caregiver and any possible risk of that treatment, and also availability of any alternative treatments, and then the possible consequences of refusing that treatment for the person they're caring for. When treatment is refused, okay, when it's refused, you need to assess and document the patient's ability to make an informed decision. Ask and repeat questions, assess the patient's answers, observe the patient's behavior, and ultimately, if they cannot, make a rational decision, if they're not capable of that, and you're not having luck with the patient's parent or caregiver, treat the patient. Again, going back to do no harm. We can figure out the rest later, and contact medical control. Let them help you out and give you some guidance. All right, so if the patient has decision-making capability, you need to, consider some stuff. Shared decision in, making it. Make it collaborative with your patient. That helps a lot because a collaborative process to come up with an optimal healthcare approach, accounting for the, unique condition of the patient, it creates buy-in with your patient. And it gives them a sense that they still have the right of choice. No matter what their condition is, they have that right of choice. Be compassionate. It's called compassionate persuasion. This is guiding that person to accept an offer of treatment. So they initially didn't want to, but if you're compassionate about it, you say, listen, this is the reason why I believe this is the best course of action for you. I want to help you. I want to make sure that your goals are met in getting to the hospital and feeling better. It works. Just talk with them. Be nice. So ultimately, if the patient appears confused or delusional, we're still talking about right to refuse treatment. You can't assume that the decision to refuse is an informed refusal. You just can't. When in doubt, providing treatment is much more defensible position than failing to treat a patient. Okay, you can defend your actions. Don't endanger yourself, obviously, to provide that care, but do everything that you can to get that consent and provide. Okay, before you leave the scene where a patient, parent, or caregiver has refused, we need some stuff. Number one, remind the patient's parent or guardians that they can call 911 back if they change their mind. This, ladies and gentlemen, is a test question. There is no doubt about that. Tell them that, hey, don't feel bad. Just because we're leaving now, you can call us back. Advise them to contact their physician as soon as possible. They should contact their personal physician if they have one. Ask the patient, parent, or caregiver to sign a refusal treatment form. And also get other departments to witness it. Maybe a police officer, they're usually one on scene, and also another department, not your department, a member of another department. A witness, that's what we're looking for there. Thoroughly document all refusals. Good stuff. It'll help you out a lot if it gets its way to court or deposition or court. All right, confidentiality. This is a big one. This will get you in a lot of trouble if you're not confidential. All patients' healthcare information, or PHI, is confidential. You can't disclose that to anybody that's not directly involved with patient care. So, confidentiality is the communication between you and your patient is considered confidential. Confidential information includes the patient's history, their medical history, their psychiatric history, their social history, any of that. Any assessments or findings that you may have, and any treatment that you provide. Now, if you inappropriately release that information, you may be liable for breach of confidentiality, which is the disclosure of information without proper authorization. In most states, records may only be released if a patient signs a release, a legal subpoena is presented, or if it's needed by the billing personnel to process a bill. Now, HIPAA, the Healthcare Insurance Portability Act. Folks, you will be tested on this. This is absolutely test question row here, man. It contains a section on patient privacy. HIPAA contains, it is a law that was enacted. It provides guidelines on which types of information are protected, and it is the responsibility of healthcare professionals regarding that protection to make sure that that information doesn't get released. There are stiff penalties for breaching that protection. HIPAA does consider all patient information you obtain in the course of providing medical treatment to a patient to be protected healthcare information, or PHI. PHI includes all medical information and any other information that might be used to identify the patient. Protecting this information includes departmental security measures regarding patient records. You will have multiple trainings on this. Any sharing of PHI, whether it's directly sharing images or recordings or verbal relaying information, is a serious violation of HIPAA. This is where your cell phones need to go in the trash. Do not take photographs, do not take recordings, do not do any of that. The only memory of these patients is going to be in your brain, and you only share that information with people that have direct care, or, as we mentioned earlier, perhaps with the billing, or obviously your company, if they were subpoenaed, would share that information if they need it in a court of law for something. Okay, continue on with this Healthcare Insurance Portability and Accountability Act. Failure to abide by these provisions can result in both civil and/or criminal actions. You can be thrown in jail for this. So just don't do it. Stay away from this 100%. The general public is often permitted by law to record, identify, and protect patient information and images. So it's only their own information. So if they want to record their own information in some way, shape, or form, the way I address this is to say you can get your records through the company. I don't just allow them to do that. No, because you got to remember, this is still protected information, even though if it belongs to them. I explain to them, well, let me protect it first. Let me get it all accurate and cleaned up and ready to go for my department, and then you can ask for that information from the department. But as a general rule of thumb, the general public can't access, you can't access somebody else's, PHI records, but the person can get their own. So that's what the statement's trying to say. Social media, ugh, I hate it. I really, really do. Unless you are operating as an official spokesperson for your agency, avoid any logos, uniforms, vehicles, or other markings that associate with your agency while off duty. Don't be taking pictures, especially patients and calls that you run, those kind of things. Let your department handle that social media part. If you want to post that, hey, I was on a great clinical today, just type that in. And I really enjoyed the station I was at. That's great. You're not identifying the station, you're not identifying the agency. You're just saying I had a good day today. Conduct yourself with the same professionalism that you do while you're on duty, and you'll be good. Respect your patients with their friends, family, bystanders, colleagues, and the organization which you work for, both in person and online. Recognize that free speech does not mean everyone has the right to say anything under circumstances and without repercussions. This, folks, is a test question. Please make sure you don't miss that one. Free speech does not mean that everyone has a right to say anything under any circumstances without repercussions, because it'll get you. You think that you have free speech, but this information, you as a healthcare provider, is protected. So don't get caught up in that social media nightmare, because it'll come back and bite you. Okay, advanced directives. You may respond to a call where a patient is dying from an illness. When you arrive at the scene, family members may not want you to resuscitate the patient. Okay, so this is where advanced directives come into place. Advanced directives are written documents specifying medical treatment for a competent patient should they become unable to make decisions. Most commonly, they're used when a patient becomes comatose. They're often referred to as a living will or healthcare directive. A do not resuscitate order, or DNAR, is quite different. In general, a valid DNAR order must meet the following requirements. Number one, it's got to have the signature of the patient or legal guardian. It needs to have a signature of one or more physicians or other licensed healthcare professionals because this attests that they are terminal. DNAR orders with expirations date must be dated the preceding 12 months. They cannot be expired. So, do not resuscitate orders doesn't mean that you don't do anything. Hear me out on this. When you encounter a patient with a do not resuscitate order, this applies to when their heart stops. If they're not breathing and they still have a pulse, you must breathe for them. The permission to withhold resuscitation means their heart has stopped and we're not going to resuscitate. Now, I do want to caution you, make sure that you know explicitly the laws of your state and the policy and protocols of who you work for, because everybody does have something different with regards to what they're going to stand up in court and say, this is our policy. So be sure you know that policy. And usually policies of the people that you work for are consistent with the rules of the state. So you'll be okay. Just make sure you know what it is when this is presented to you, because this does happen. These are some figures or examples of the DNRs. One's a wallet size, the other one is a full size. Every state has a different one, and they even have different colors. So be aware, like I said, of what you're operating under for the state that you're in. Okay, so you may encounter some other different types of life-sustaining, treatment withholding, such as POLST and medical orders for life-sustaining treatment, MOLST. These forms are caring for patients with terminal illnesses. Generally, these kind of medical orders explicitly describe acceptable interventions. Whether you're going to brief them, whether you're going to do CPR, they must be signed by an authorized medical professional, be valid. If you encounter these documents, contact medical control for guidance. Now, during this time, you are going to have to be doing something for the patient. So remember, until it's validated and you speak with medical control, you're going to have to do what's necessary to do no harm for your patients. Now, some patients have named surrogates to make decisions for them. What they do is they have a durable power of attorney for healthcare. It's also known as healthcare proxies. Make sure that you know what your local protocol is and what your local laws and regulations are concerning these kind of documents. All right, so do not resuscitate means do not treat. Even with the DNAR you are obligated to provide supportive measures, what we call palliative care, which include oxygen, pain relief, and comfort to a patient who is not in cardiac arrest. Remember, the key is not in cardiac arrest, okay? You have to treat patients, give them palliative care, take care of them, be their advocate. Patients may be receiving palliative care already, a treatment approach where focus on decreasing pain or symptoms rather than prolonging life. Each ambulance service should have a protocol to follow in these circumstances. The number of hospice and in-life home healthcare agencies is growing, so you may be faced with these situations. And remember, you always have med control, okay? If you have a situation, contact your department, contact your medical control, contact your medical director, doctor. Somebody is going to help you through this if you don't know what to do. Physical signs of death. How do we determine the cause of death? Well, we have presumptive signs: unresponsive to painful stimuli, lack of carotid pulse or heartbeat, absent of chest rise and fall, no deep tendon corneal reflexes. Presumptive signs of death continued, absence of pupillary activity. Their pupils are fixed and dilated, no systolic blood pressure, profound cyanosis. Otherwise, they're pretty blue, all over the place. And they may be cold, lowered or decreased body temperature. Now, these are definitive. This is absolute definitive. This person has passed on, they're dead. There's nothing you're going to do for them. Obvious mortal injuries such as decapitation. We can't fix that, folks. So that's pretty obvious, nothing we can do for that. Putrefaction or decomposition, that means their tissues are beginning to break down. Transection of the torso, otherwise they've been cut in half. Incineration, they've been burned beyond all recognition, or injuries that are incompatible with life, which you'll see somebody ejected from a car, they're split in half, their body parts have been torn off from their trunk, all the appendages, they bled to death. When you see something like this, it's very obvious. This next slide is definitely dependent lividity. It's an interesting one to see. There you go. This is an obvious sign of death. The blood has pooled into the lowest point of the body, wherever they were laying. This person was laying on their back, causing that skin discoloration. You will see that on a test question, so make sure you know what dependent lividity is. Rigor mortis is the stiffening. Algor mortis, rigor mortis is a stiffening of the body caused by chemical changes within the tissue. It's usually within 2 to 12, and algor mortis is the cooling of the body until it matches the ambient temperature of whatever the body's in. And it can be either blunt or penetrating trauma in a patient who's apneic and pulseless with no other signs of life. We'll put an EKG on them to verify that there's no electrocardiographic activity, and we'll be looking at pupillary responses as well to verify death. Medical examiner cases, this happens. This is where the medical examiner needs to be involved. It depends on the nature and the scene of death. In most cases, the medical examiner or coroner in some states must be notified under these following circumstances. You see them here. Death on arrival, death without previous care, suicide. These are all things that are questionable. It's something that's questionable type of death. This is where the medical cases get involved. And sometimes you may have to help out on scene until you're released with answering questions of anything you may have done before you got there. So expect to stay around for a little while in these kind of cases until you've given the coroner, the medical examiner, all the information they need. So organ donors, this is a consent to organ donation. It's voluntary and knowing. Consent is evidenced by information on the driver's license or donor card. Be aware of the local centers and the protocols, and obviously what your protocols are. You may have a patient that is an organ donor. You're asked to prolong their life by doing CPR and transferring them to a center which the removal or harvesting of those organs can be done. So you have to oxygenate the body. This is usually with younger people, anywhere between the ages of 18 and say 30, 35, somewhere around there, in good health, those kind of things. And like I said, it's on their driver's license. So if you're working a code trying to determine how somebody look at that driver's license, A, to identify who this person is, and B, also see if they're an organ donor as well. There's an example of the cards you may find. If it's not on their driver's license, they may have this card in their wallet. All right, so medical identification insignias. This is stuff that you're looking for when the patient can't speak for themselves. Very common with patients that have allergies or diabetics or epilepsy or anything that suddenly can incapacitate them. These are bracelets that are worn on them. They may even be a QR code or on a USB drive that they keep in their pocket. You just never know. Or it could be just tattooed on their skin. Hey, I'm a diabetic, or hey, don't give me epinephrine, I'm allergic to it, kind of thing. I have my epi in my purse. I know a story behind that. If you ask me sometime, I'll be more than happy to tell you what it is. A woman lost her life because the paramedic gave her their epi versus giving her epi that was in her purse. Okay, so that's the bracelet, and as you can see on the back side, now they have the QR codes on the back and IDs. You can call this number to find exactly what's wrong with this patient, what their medical alert is. Scope of practice. Hey, it outlines the care you're legally able to do. You will not be allowed to do brain surgery as an EMT. I promise you. You'll get that later if you go to college and become a surgeon. So anyhow, that's usually defined by state law. Okay, usually defined by state law. The medical director further defines the scope of practice by developing the protocols or standing orders, which are online. Okay. You have a difference between online and provided, or offline. The protocols and the standing orders are offline. The talking to the medical director on the phone is online. Remember that. That's a test question. So we'll talk about that here in a little bit, but that's how you get, if you need help, you're online with the medical direction. They'll help you, or you look it up in your protocols to make a definitive decision. So, authorization to provide care is given by the medical director, period, as we were talking about, either the telephone or radio, which is online, or standing orders, which is offline. Practicing outside of your scope of practice can be considered as negligent. So, don't do it. Don't do brain surgery on the side of the road. That's a bad plan. Okay, the manner in which you must act or behave is called the standard of care. So the standard is that you provide, care with the philosophy of do no harm. So standards of care are established by local customs. Okay, how reasonably prudent a person with similar training and experience would act under similar circumstances with similar equipment and in the same similar place. Okay, that's what you're held to. That's the standard. Now, standards imposed by law are the standards of emergency medical care. They may be posed by statutes, ordinances, administrations, regulations, or case law. In Florida, because we're in Florida, I can tell you that you have 401, which is our Florida statute, and then you have 64J, the way it's currently written, that takes care of all the administrative codes. So we have laws and administrative codes. Be familiar with these, okay? Be familiar with the particular legal standards that are in your state. Professional or institutional standards. So this is the recommendations published by the organization and societies that are involved in emergency medical care. For example, the American Heart Association. Your BLS for CPR, you're learning that while you're in school. It is, provided by the American Heart Association. They do the research and they publish the publications that tell you how to do CPR. They are very specific, okay, for that organization. Just like your institution, they will have rules and procedures at your EMS agency. So that is your internal standards that are given to you that we refer to as protocols. All right, so standards imposed by textbook. So let's talk about that. We have a textbook that we operate off of. Almost all textbooks follow the standards established by the National Highway Traffic Safety Administration, NHTSA. Folks, you need to know this. These are the folks that put together the standards that you follow. In your objectives, you will notice in the first page of every single, we talked about this in orientation, every single chapter has national competencies right on top. And then you have the knowledge objectives down below it. The NHTSA component, the national standards, is what applies across the entire United States. Okay. Always remember that local protocols, okay, may different. So you always will follow your local protocol, but you need to always be aware and know what at least the national standards are in case you move from one state to another. Standards that are imposed by states are called under the Medical Practices Act. In some states, the EMT is exempt from the licensure requirements of the Medical Practice Acts, so they get certification. So, right, so certification and licensure. After passing the initial certification exams, candidates need to require whatever certification is required for the state, whether it's licensure, whether it's credentialing, that kind of stuff. Some states require you to take their state exam, other states require that you take national registry. Once you are certified as an EMT, you're obligated to conform with those competency standards that are recognized nationally by the National Professionals of EMS organizations, as well as the state that you're working in. EMTs must ensure that their certification or licensure remains current and that the knowledge and skill levels are kept up to date. So, an individual's responsibility to provide patient care. This is what we refer to as duty to act. Once your ambulance responds to a call or treatment has begun, you have a legal duty to act. In most cases, if you are off duty and come upon a crash, you're not legally obligated to stop and assist patients. You need to know your local laws and policies. Most commonly, this is called the Good Samaritan Act. You know, it's a legal ethical issue. If you're trained and you're not under the duty to act and you decide, I'm going to help this person anyway, I'm off duty, you can't be held liable for that unless you fall outside of your scope of practice. So once again, no brain surgery on the side of the road, just doesn't work. So it only applies if intervening while off duty, you must continue to provide that competent care until an equal or higher medical authority assumes care. Once you've begun treatment, don't stop until another EMT takes over or a higher person, such as a paramedic, a doctor, or a nurse. Negligence. So negligence is the failure to provide the same care that a person with similar training would provide in the same or similar situation. To prove or to determine that negligence has happened, you must prove the following. Duty. That the obligation to provide care and to do so in a manner that's consistent with standards of care that's established by training and local protocols. That's your duty, okay? And you failed to provide it. That's where the breach comes from. You didn't act within that expectation, okay? That reasonable standard of care. And the next is damages. A patient's physical, okay, or psychological was harmed or degraded in some way, some noticeable way. And then finally, you have to have a relationship of causation, which means a cause and effect relationship exists between the breach of duty and the damages suffered by the patient. You got to have all four of those to prove negligence. All right, so res ispitor locator. I hope I said that right. I never get it right, but I think I was pretty close that time. This is when an EMT can be held liable under this theory if it can be shown that an injury occurred, that the cause of the injury was in the control of the EMT, and that such injuries generally do not occur unless there is negligence. So one of those still a negligent type of proof thing, but it's very specific on what the EMT did. Negligence per se, that's when the conduct of one person being sued is alleged to that occurred in a clear violation of statute. So they violated a statute and caused the negligence. And then finally, an example of that would be an EMT performed an ALS skill that resulted in the injury of the patient. EMTs don't perform ALS skills. That's a clear violation of statute. Torts, it's civil wrongs. Okay, there's something wrong that has been picked up by the courts. That's going to be a civil type of proceedings. It's not within the jurisdiction of the U.S. criminal court, so it falls under a civil liability. Examples include defamation of character and invasion of privacy. Abandonment. Abandonment is a unilateral termination of care by the EMT without making any provisions for care to be continued by another medical professional who's competent and trained either at an equal or higher level. So bottom line is that once you have started care, you've assumed that duty to act, that it must continue until an equally or competent medical professional assumes responsibility. Abandonment may take place either at the scene or in the emergency department where you're dropping off your patient. Part of your obligation as an EMT is to provide the hospital personnel with your assessment, findings, care, any changes in the patient's status, their valuables being turned over, all that kind of stuff you're responsible for. Obtain a signature on the patient care record from the person accepting the transfer of care at the hospital. Make sure you can read legibly their name or at least an ID number. Assault, battery, and kidnapping. Assault is the unlawful placing of a person in fear of immediately bodily harm. This includes threatening to restrain a patient who does not want to be transported. Battery is unlawfully touching a person. This includes emergency or providing emergency care without consent. And then kidnapping, seizing or abducting, confining, or carrying away by force. This could include a situation where a patient's transported against their will. False imprisonment is the unauthorized confinement of a person. Serious legal implications and problems can occur out of this, so just don't do it. Make sure you have your consents or that you can prove incapacitation. So be very careful. Don't get charged with these things. Do what's right. And again, call for help as necessary. Use law enforcement as necessary. Defamation. Two different types, libel and slander. Libel, just what it says. It's written. You said something bad about somebody, wrote it down. Slander, that's the spoken word itself. Can you be charged with both? Yeah, if you do both. So know the difference between the two. Because once again, both of these are test questions. Seen it. Good Samaritan laws. We've talked about this. If you reasonably help another person, okay, you don't do brain surgery on them or anything outside of your scope of practice, you're going to be okay if you don't have a duty to act. You have to be off duty. You have to be doing it in good faith without an expectation of compensation within the scope of your training, and you were not acting in a grossly negligent manner. Gross negligence, conduct constitutes a willful or reckless disregard. So once again, we go back to the patient that you want to help, the good person, the good citizen in your community that's fallen out of a tree, and you're not working, and you go up there and help them. Immunity statutes, sometimes they apply to EMS systems if they're a governmental agency. So, if you work, like a lot of contractors are working on a base, and they may or may not fall under the governmental immunity, but those that are in the military are definitely within the governmental immunity. Or if you work for a county or a city, you would fall under governmental immunity. Records and report, safeguard, period. Don't let people see them. Remember HIPAA. Don't divulge that information. Don't get involved in that business. Courts to consider. An action is not recorded, is not performed. Okay. So if you don't record it, you didn't do it. Bottom line, you need to make sure that you put down what you want. And always remember, and this is a test question as well, if you have an untidy or crappy or a poor report, it's a direct reflection on the patient care that you gave. There's no two ways about it. A judge will see that and come down on you a lot harder than anybody else because you didn't document it. Like I said, if you didn't document it, it wasn't done. All right, so NIMSIS, it provides the ability, it's called the National EMS Information System. Okay, it provides the ability to collect and store and share standardized EMS data throughout the United States, primarily trauma. This is so we can improve what we do. Like right now, we're collecting a lot of data on blood in the field, giving patient blood in the field and the survival rates. So all kinds of things come from this because remember, everything in EMS improves based on research. Special mandatory requirements. So this is stuff that you have to report. Okay, child abuse, abuse of an older person, abuse of other people that are at risk, an injury during the commission of a felony, drug-related injuries, childbirth, all these things are reportable. So you need to make sure that you may have some additional ones wherever you work, whatever state that you work for. So be sure that you know what they are. Other reporting requirements, burns, especially in children under a certain age, attempted suicide, dog bites, all of these. These are in your book, read up on them. Fail to report these could get you in a lot of trouble, including maybe even criminal prosecution. So be very careful with this. Make sure you report these things. Make sure you know what is reportable within your state and your department. Scene of a crime. If there's evidence that a crime has been committed, okay, notify the dispatcher immediately so that law enforcement authorities can be dispatched. Ensure that the scene is safe to enter and provide life-saving care as need be to anybody that's on scene that needs it. Just because it's a crime scene doesn't mean that we don't do anything. When you're providing care, please be careful not to disturb the scene. There's certain things that we don't do, like for instance, when you're cutting clothes off, don't cut through a bullet hole. Don't cut through a knife hole because that is all discoverable criminal information. It's evidence. Preserve the forensic evidence, whatever you can. Many hospitals have sexual assault nurses. Again, that's a whole different ballgame. We'll talk about that a little bit later on. When we're talking about emergencies, we're talking about genitourinary emergencies. Rape is one of them. We got to preserve that evidence. Don't let her go to the bathroom. Don't let her wash. Get her transported as soon as possible, just like she is. Once again, many hospitals do have the sexual assault nurses trained in caring for the patients in sexual assault and evidence collection. So make sure you follow through with that. So the EMT in court. You can end up in court. In most cases, you give a deposition. And if your documentation is really good and you're very thorough in what you documented, most commonly you don't ever end up in court. You'll do your deposition. That's usually the end of it. But if you end up in court, you may be a witness or you may be a defendant. The case may be either civil or it could be criminal. Whenever you're called to testify, okay, notify your service director, whoever you're working for, and also any legal counsel. Legal counsel primarily will be taken care of through the service that you work for, but you also may want to, purchase on your own some professional liability insurance. HPSO through Geico, I believe, is a subsidiary of it. HPSO it's a agency that you can get insurance, but there's many other places you can get professional liability insurance. If you're a witness, just always remember, remain neutral during your testimony. Give the facts. Don't add any opinions or anything else. Review your patient care report before your court appearance. I always tell people that when you're being interviewed in a deposition or if you end up in court, refer to your PCR. Say, refer to my report, refer to my report. If they ask you questions, you're not going to remember a patient that you transported a year ago, 6 months ago, even maybe 6 weeks ago. So refer to my report, or please provide me with a copy of my report and I will answer your questions, that kind of thing. Okay, so as a defendant, an attorney is required. You just need to have one, period. Defenses could include, statute of limitations, the time within which the claim may be initiated, contributory negligence, which is a legal defense that may be raised when the defendant believes that the conduct of the plaintiff somehow contributed to the injuries or damages sustained by the plaintiff. I want you to remember that because that is a test question. You're going to see that on your exam, so definitely remember that one. Statute of limitations, I'm sure, is on there, but I know for a fact recent exam that I took had that on there, so make sure you know that one for sure. Discovery. Hey, it's an opportunity for both sides to get information, plain and simple, so they can all reach a better understanding about the case. Usually these are handled by interrogatories, which are written requests, okay, questions, and then depositions, which are oral requests. I've been to both. I've sat down and done an interrogatory and answered questions that they had, sent them in depositions, but I've only made it to court maybe once or twice in my career. And I was pretty much so dismissed when I said refer to my report because it was all there. If you're good at your reporting, you document everything, you'll be okay. Most cases, they're settled following the discovery phase. You don't go to trial. For those that you do go to trial, several types of damages may be awarded. Compensatory damages, they're intended to compensate the plaintiff for injuries that they sustained. Punitive damages are not commonly awarded in negligent cases and are reserved for cases where the defendant has acted intentionally or with reckless disregard. Any EMT that's charged with a criminal offense should secure the services of highly experienced criminal attorneys. In most cases, if a judgment is rendered against you, your service or its insurance carrier will pay that judgment. Any EMT charged with a criminal offense should secure those services. Usually that happens within your agency. They provide that for you because these don't happen for the side of the road stuff. Because that's, if you're not on duty, that's not a breach of act, and it falls under the Good Samaritan Act. So those really don't go to court. They just don't. They're non-winnable. But when you're on duty, yeah, because everybody has a target on their back depending on who you work for. The bigger the target, it'd be like your air ambulance operators, helicopter operators, those kind of things, fire departments, that kind of stuff. Ethicals, okay. Ethical responsibilities. Ethics, okay. Ethics is a person's moral philosophy of right and wrong. The moral duties and of the ideal professional behavior of whatever you're performing, whether you're a paramedic, whether you're a doctor, whether you're an EMT. Morality is a code of conduct affecting character and conscious and the definition of right versus wrong. Bioethics specifically addresses ethical issues that arise in the practice of healthcare. Folks, remember this one for sure. I've seen it both at National Registry exam and also on your local exams. Applied ethics is the manner in which the principles of the ethics are incorporated in your professional conduct. So it's how you apply them. All right, so ethical responsibilities, you're going to encounter several different dilemmas that you're going to go, be involved with. There's drug cases, there's criminal cases, there's just all kinds of stuff. But it's the manner in which you respond, okay? It requires you to evaluate and apply your own moral standards as well as ethical standards of your profession. Okay, plain and simple. You gotta run, would I do this or would somebody else like me do this? I mean, am I making the right decision? So, it allows for rules and laws and policies to guide your decision-making processes. And there's a good table here. We're going to look at it. It's called Table 3.2 out of your book. There you go. That's it. Table 3.2. Ask yourself these questions. It'll help. It'll help when you got to make these decisions. All right, so let's do a review. Okay, well, I know. I hope this is helpful for you guys at the end because I like doing these reviews because it challenges you to think. Okay, so here we go. Question 1. You arrive at the scene of an older woman complaining of chest pain. In assessing her, she holds her arm out for you to take her blood pressure. This is an example of, come on, you can do it. All right, if you said C, You are correct. Expressed. Okay. Actual consent. She held her arm out too. Said, sure, go ahead, Sonny. Take my blood pressure. Here's the rationale behind it. 2. Which of the following is an example of abandonment? Da, 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 da. You can do it. If you answer D, that is correct. It's when the termination of patient care has been caused without consent or without, giving this person to a higher level of care. All right, so not going to work. And here's your rationale on it. You can always pause and reread these because it's always a good thing. You can write them down and it'll help you with your tests, for your future. All right, let's move on. The unauthorized confinement of a person is called. If you said C, you are correct. Okay, confinement of a person without legal authority or the person's consent. Rationale. Number 4. Failure of the EMT to provide the same care as another EMT with the same training is called. Come on. Negligence. Yes, negligence. C. Okay. There's the rationale behind it. Number 5. An 8-year-old boy was struck by a car, is unconscious and bleeding from the mouth. A police officer tells you he is unable to contact the child's parents. You should. 8-year-old, what should you do? You can do it. It's a child, no parents around. It's an emergency. It's life-threatening. Not good. It's unconscious. If you said A, you are correct. Emergent care. It's a child. Can't give their own consent. Okay, it doesn't matter. It's an emergency. Life-threatening. Take care of the child. Transport them immediately. There's your rationale. Number 6, advanced directives. You remember this. We talked about this. It is C. Yeah, C. Okay. Advanced directive is a document signed by the patient and witnessed, okay, on how they're going to be taken care of. Most commonly, this is in the hospital. Anytime you go to the hospital, they ask if you have advanced directives. Here's your rationale. Number 7, which of the following patients are competent and can legally refuse care? Can't be confused. Can't be drinking beers. Can't be a diabetic with slurred speech, so C. Correct. Right. Patient's legal age, 18 in most states, is conscious and alert. There you go. Person, place, time, and event. We've talked about this. There's your rationale. Number 8, you're treating a patient with apparent emotional crisis. After the patient refuses treatment, you tell him you'll call the police and have him restrained if he does not give you consent. Your actions in this case is an example of. Remember, it says you're treating a patient with apparent emotional. If they refuse, you're going to restrain them. So if you restrain them, you put your hands on them. You're putting your hands on them already. You are committing assault. Unlawfully placing a person in fear of immediately bodily harm, okay, without conscious, without consent, constitutes assault. You're unlawfully, you're putting them in fear of body harm, that kind of thing. So you're assaulting them. You're not quite battering them unless you're touching them and doing blood pressures and sticking with needles, or well, you guys wouldn't be doing that. But if you actually touch them, that's battery. But you're putting them in fear of bodily harm at this point, so it's assault. There's the rationale. There's the battery about touching, negligence, abandonment, so on and so forth. The EMT has a legal duty to act if they are you can do it. Here we go. B, paid or volunteer. Even if you volunteer, once you walk onto that truck and walk into that department, you have a duty to act. Okay? If you're on duty and dispatched to the call, regardless of the nature of the call, doesn't matter. You have a moral obligation, but not necessarily a legal one. It doesn't matter. You have a duty to act, especially if you're paid. That's the big one. The EMT has a legal duty to act if there's your rationale behind them. Okay, there we go. Whether paid or volunteer. All right, number 10. Which of the following statements about records and reports is false? And if you answer D, you are correct. Ding, ding, ding. There you go. That is not correct. Doesn't matter. This is a continuum of care. Your patient care report, your PCR, follows the patient through. It's a permanent part of their record. There's the rationale. All right, folks, once again, it's been awesome. I hope you learned something on this. We'll see you in class.